I think we're going to go ahead and get started this morning. The Public Utilities Commission of Ohio has called for a workshop at this time and place, case number 24-1039 EL ORD, which is captioned in the matter of the Commission's review of Ohio Administrative Code Chapter 4901:1-22 regarding interconnection standards. I'd like to welcome you all here this morning and those that might be watching our webcast this morning as well. My name is Megan Addison. I'm the Administrative Law Judge assigned to preside over the workshop this morning. As noted in the November 6th, 2024 entry, the purpose of this proceeding is to review the rules contained in Ohio Administrative Code Chapter 4901:1-22 and to determine whether revisions are necessary to the Commission's interconnection standards. Pursuant to that entry, the workshop was scheduled to allow stakeholders a chance to propose revisions and provide feedback for our consideration. This is meant to be a more informal discussion today. We do not have a court reporter. This is not being transcribed. We welcome any feedback or comments that you may have, and anything said today will not be binding on any stakeholders. If you do have comments you'd like to share, we just ask that you come up to the front, perhaps turn on the microphone, and introduce yourself before presenting those. Following today's workshop, the Commission will invite interested stakeholders to provide written comments and reply comments on the rules in this chapter, including any recommended changes staff may have. With that, I'll go ahead and introduce the staff members who will be helping me today this morning. On my left, we have Christina Schaefer, Kristen Klingen, and Megan DeLisi. And I believe, Kristen, you may have a few opening remarks before we go ahead and take our comments this morning, or if we'd like to go ahead and dive into comments.
Good morning, I'm Kristen Klingen. Thank you all for coming and for being here. As many of you know, we have been working on potential proposed changes to the interconnection rule for some time, following the previous rule review, which actually started in 2018 and was finalized in early 2021. Or 2022, excuse me. The Commission had created a DER stakeholder work group to talk about some of the issues that were raised in the previous rule review. That work group had ongoing meetings in 2022 and 2023. And so we're really here today to formally kick off the next rule review and propose changes that anyone may see as being necessary or warranted in the next rule review. So this is the opportunity to make comments on the existing rule and any issues that may have been discussed in the DER stakeholder work group over the last couple of years. So thanks again for coming. Appreciate it.
Thank you very much, Kristen. And with that, I'll go ahead and open the floor. If you do have comments, we just ask everyone come up one at a time. Again, introduce yourself, and then you can provide us any comments that you may have. Welcome.
Hi, Justin Price, First Energy, on behalf of the three companies, Toledo Edison, Ohio Edison, and Cleveland Electric Illuminating Company. My role within the companies, I'm a manager of distribution planning and protection. So my oversight is our DER interconnection process and other distribution planning and protection philosophies, guidelines. I did participate in the DER work group and was the chair kind of the second year of the group. Just like to kind of say, we're grateful for the staff for facilitating the DER working group and coordinating the stakeholder engagement and feedback through these rules and those discussions. The companies are supportive of the efforts to modernize the rules, including the adoption of the IEEE Standard 1547-2018, which would codify the current best practices for safe and reliable DER interconnections. And thirdly, the companies are supportive of the efforts to clarify and simplify the interconnection process for all stakeholders while ensuring the safe and reliable operation of our electric grid.
Thank you very much,
Thank you.
Mr. Price. Welcome.
Good morning, Your Honor, and PUCO staff. My name's Karen Nordstrom. I'm the clean energy attorney for the Ohio Environmental Council, and echo the sentiments of the previous speaker. Thank you to the PUCO staff for your careful and thoughtful consideration of these rules and interconnection. These rules will set really important standards going forward as our grid continues to modernize, and distributed energy resources will be a critical piece of our grid moving forward. And so in that respect, the rules, there are some updates to the rules based on technology that the Ohio Environmental Council would like to see. Starting with the definitions, we do see it would be helpful to add a definition of export capacity, given the changes in technology with DERs now such that they're able to regulate better what they're exporting into the grid. And so changing or creating a definition of export capacity for a maximum nameplate rating, except where the capacity is limited by industry accepted export limitation methods. And then similar to the previous commenter, staff is probably already planning to include the IEEE standard 1547, a 2018 update, as well as the 2018 errata into section 4901 1-22-03. But OEC is, of course, supportive of that. So the rules in 4901 1-22-06B1, and then the mirroring section for level 2 interconnection currently use 15% of the annual peak load, but it's our understanding that with updates in technology, the use of minimum load is now a more accurate metric to use for eligibility and reviewing level 1 and level 2 interconnection. And so we would ask to switch that to 100% of minimum load in place of the current 15% of peak load requirement. And, pardon me, and we also would ask to implement a hosting capacity map language into the rules. We understand that all of the utilities have at least submitted through stipulation some sort of hosting capacity map language, but we do think that having a consistent language throughout the utilities with a specific deadline for all of the utilities to bring those maps online creates consistency across the state, so that there's not a patchwork of maps that favors certain areas of the state being able to view and understand and choose for interconnection more quickly. I think it would level the playing field for those looking to interconnect and seeing where they can. And I think those are our initial comments. We look forward to submitting written comments and appreciate the opportunity from Your Honor and from staff. Thank you.
Thank you very much, Ms. Nordstrom.
Hi, good morning. Larissa Vaisman for Duke Energy, Ohio. So just a few brief comments. Again, echoing everyone else, thank you to the staff for running the work group. I think a lot of really good feedback has been collected. We just have a few comments at this time. One of the items that was discussed during the work group was kind of a level 1.1 generation and energy storage. So just two items for consideration. One is whether the staff would like to see either a brand new kind of level 1.1 application form for that should be designed, or whether the current level 1 application form should be modified, with appropriate fields or subfields added for level 1.1. And also, Duke Energy Ohio believes that at least for some time initially, it would be good to allow additional time for review of any level 1.1 or applications involving storage, just because it is something relatively new and there are a number of technical dimensions that could come into play. So that's one item. Just a brief portion of an existing rule, Rule 22-04G4. There's a requirement that all construction and system upgrade cost estimates and invoices shall be itemized and clearly explained. And something that we would find helpful is just a little bit of clarity on the clearly explained portion of the rule, and whether that is more intended to be an explanation of the need for the upgrade, or an explanation of the amount of cost, or why the cost is what it is, sort of the same thing as itemization, essentially. And finally, something that Duke Energy Ohio would find helpful is that to add a requirement that payment of all interconnection fees would be required prior to commencing construction of any upgrades. And so obviously we will, like other parties, probably submit written comments as well, but those were just a few things in addition to what's been shared with the work group that we thought we would share here today. Thank you.
Thank you very much, Ms. Vaisman.
Your Honor, with your permission, I thought I would just give you written copies of informal comments, and that we don't have to read the whole thing to you. Is that okay?
Certainly.
No one likes to hear me read. I guess I don't have to say ladies and gentlemen for the first time in a while. So ladies, my name is Jeremy Kent. I'm the Chief Executive Officer of One Power Company. One Power is based in Findlay, Ohio. We are the largest interconnector of behind-the-meter wind in the state of Ohio. I don't know if we're the largest behind-the-meter generator for renewables in Ohio, but we're at least in the top few for every utility in the state. I had the privilege of working with the committee that was, or the working group that was so thoroughly run and went through line by line painstakingly, and I appreciate all that time and effort. And it occurred to me that we have a framing problem. This isn't one issue of interconnects. This is the small guys and the big guys, and this is the behind the meter and the in front of the meter. And I think that as the commission and staff approaches how to rethink this issue, I would respectfully suggest that that framing be front of mind. The way that you put a solar panel on your roof at your house is entirely different than the way that I put a 15 megawatt behind the meter system in to help power Whirlpool. We operate a different caliber, we have different expectations. I can kill people. My systems have enough fault current to kill people. They can override the grid, they can shove power back out there. And when that car hits that wooden power line, if I don't have the right protection and control settings in, I will kill people. That's the reality of our business. The solar panel on your roof is not going to do that. And so I think that as we talk about a lot of these standards, we need to remember that there are different classes of this. So when you're talking about a larger system, generally above 1 megawatt, I feel like there should be a very different standard of care. If the commission just adopts 2018's version of 1547, and it allows utilities to impose low voltage ride-through and zero voltage ride-through, it will be requiring me to kill people. I really don't want to do that. So right now, our systems are designed to detect anomalies in voltage and frequency and current and respond to those almost immediately. We respond in between 3 and 7 cycles. That's the way that I'm able to say that if there's a fault, I'm not going to feed into that fault. With low voltage ride-through and zero voltage ride-through, those exact same signals that I use to protect everybody today, I have to ignore. And I don't know that the commission has the statutory authority to do that, but besides that point anyways, I would say the commission just shouldn't do that. And so I also have to acknowledge that the utilities have a challenge in front of them, right? There are now systems you can buy on Amazon that let you put a little solar panel on your roof and just plug it in through an inverter and not even tell the utility, fully acknowledging you're supposed to, but let's not pretend everybody does. There is this problem of small behind-the-meter systems showing up everywhere. And in cases like that, I have no problem with 1547, 2018, or at least all the provisions in there. And so maybe there's a way to do this as a hybrid where you look at small systems and big systems. But if you look at them the same, you're creating safety issues for every large industrial that decides they want to go ahead and adopt behind-the-meter generation. And I don't think that's the intent of this commission. I don't think that's the intent of the standard. I also think, and I didn't actually fully understand this until the working group, so thank you for that. Utilities are thinking about systems in a similar way, and I'm not sure they should be when we talk about in front of the meter and behind the meter. If I go to a Marathon petroleum refinery and I put up some wind turbines behind the meter and I'm protected under the laws that relate to net metered systems, that is very different than if I go into the middle of a field where no one's around and I say that I want to be a generator and tie in here. Those are two very different engineering problems, and they're also two very different statutory regimes in the state of Ohio. Net metered systems have specific protections in 492867D that are not afforded to non-net metered systems. There is an explicit limit saying that utilities cannot impose other requirements beyond those enumerated in the revised code for net metered systems. That same protection does not, to my knowledge, exist for non-net metered systems. Right now, the current version of OAC does not parse that well, in my opinion. I think that it would be constructive to think about how in front of the meter systems that our generators trying to generate are treated relative to behind the meter systems, which are afforded certain protections that are explicitly applied to them. So I would suggest that that point gets further attention as the standard is drafted, because I did not realize until we all started talking past each other that we were talking about two very different things in the same conversation. So I would respectfully submit that that should be part of the conversation. And then finally, the newest issue that we're seeing that I would hope a rewrite would be able to address is the what we call kick it to transmission and hope system. So we have seen utilities, the actual regulated EDU that this commission has authority over, take our application, say, well, we've deemed this to be transmission, hand it to their transmission affiliate, and let their transmission affiliate run their own process under their own standards. For net metered systems, when they apply additional standards beyond those enumerated, that is blatantly unlawful. I'm seeing more and more that the utilities are being directed to take more and more systems that were never considered transmission before, that were at best sub-transmission, and now consider them transmission and hand them to the transmission engineers. There's two problems with that. One, the transmission engineers are not applying the standards correctly, and as some members of this commission staff have seen, we've been on calls with transmission engineers saying, no, we're applying a company standard. We would like to see a second redundant relay. And when we push back and say, why a second relay? The standard does not require that. Well, company policy does. Okay, whose company policy? Well, the transmission company's policy. the reality is the transmission company's policy is not germane to those systems that are protected by the net metering protections in .67. And so I think that it needs to be clear that there's a protection that no matter who's reviewing it, you're still under the same standards for net metered systems. But two, frankly, I think that kicking it to the transmission team is completely inappropriate. I think that the fact that on a call with commission staff present, I was able to have an EDU engineer who was not involved in a prior project with us pull up our application for that prior project, read our confidential information back to us, and then be able to talk about that confidential information. This is our proprietary designs for how we've done things for a project that engineer was not in any way affiliated with. That's concerning, especially because it was the transmission arm of the utility that isn't regulated by this commission. So I'm not sure why, in order to turn an application to an EDU that's regulated, I have to give stuff to their non-regulated affiliate. I would propose that customers for larger facilities, again, thinking about small versus large, have the ability to request a third-party engineering firm. I can't see why I have to give something to somebody who's my direct competition in order to interconnect, when we could very easily hire a third-party engineering firm who could, do that study to the same level that everybody else is getting their studies done to. But I think that the commission ought to think about that as we start talking more about the transmission systems versus not transmission systems and how those are all merging together in ways that I'm not sure that the revised code or the original standard ever contemplated. So again, overall, I think the working group did an excellent job of fleshing the issues out. I think there were issues I didn't fully understand, so I appreciate that. But I would respectfully submit to the commission that there's a grid, and the grid is 2 by 2, and that is small systems, big systems, in front of the meter, behind the meter. And I think we need to think about how we treat all of those separately to make sure they're all appropriately addressed. And with that, I thank you for taking comments. I'm happy to answer any questions, and if not, thank you for your time.
Thank you, Mr. Kent.
Thank you.
Hi, Larissa Baseman for Duke Energy again. Just briefly wondering if it would be possible to get a copy of the comments that were given to staff for other parties to get a copy of those?
We have some extra copies we're happy to make available, and I'm happy to email as well.
Okay, wonderful.
Thank you, Mr. Kent. Welcome.
Good morning. May I approach with written comments as well?
You may. Thank you so much.
Good morning. Thank you for having us today. My name is Adam Davis. I represent EDP Renewables. We're a large utility and distributed generation renewable company with operations in Ohio and also large plans for Ohio. Appreciate the time today and have worked extensively with staff over the last 2 years on both in the working groups as well as on specific issues that we brought forward with our experience. I want to focus today really specifically on level 3 and appreciate Mr. Kent's clarifications on front of the meter and behind the meter. I'm talking today specifically about front of the meter level 3 interconnections. Frankly, they take too long and they're too expensive in Ohio. EDPR is in a unique position as a large-scale developer. In the last 2 years, we've submitted 46, possibly more this week, front-of-the-meter level 3 interconnections, generally spread across all of the IOUs in the state. And over that time, we've seen really no improvement in the process from the utilities. When we submitted, it took us about 6 months to get the first interconnection application started with support from staff. And over that time, the process has not improved. We have seen, results all over the place We're waiting on some studies that have taken over 1 year for a level 3 system impact study. The clock is still ticking on that. Facility studies are taking, an additional very long time for those utilities that require them as well. One thing that is just really clear is that the current level 3 guidance, specifically without timeframes, just leaves us in the dark. We're really finding our way, and there is no statutory limit for how long these studies can take. Compare this to other states with successful DG programs, and it's really abnormal. Another issue that we've seen, primarily because of lack of guidance in the rules, is just very variable costs between the EDUs for interconnection upgrades and mitigations. I think this is a combination of lack of experience with front-of-the-meter interconnections, and certainly as one of the first movers in large front-of-the-meter interconnections, we can understand that, but it has been 2 years, and we're really not seeing improvement. This includes things such as over-engineering of protections, what we've called gold plating in other states. Certainly the lack of a unified approach on the IEEE 1547 standards. In general, we are in support of the rules, and it's been applied very differently across EDUs in the state. Specifically, the current inverter technologies, which lead to over-engineered system mitigations and really high costs. Similar to Mr. Kent's remarks, we've also seen reviews kicked up to the transmission group or other groups, including the planning and controls group, which really turns into a black hole. Again, I think a lack of guidance in the timeframes permitted or allowed within the rules is a factor there. We're just not prioritized, simply put. One thing that also note is that many of our EDUs here have franchises in other states, and we're seeing inconsistencies. As a large developer that's present in many states, we have a data set to work for and have seen across the IOUs where we have footprints in other states, very different methodologies in the study process, in the mitigation, and certainly in the cost and the time frame. Many of these states where these other franchises operate have much more clear guidance. Some of these do not, and yet we still see differences. Next door we have a hearing on the data centers. There's a really acute need for new generation in the state. Distributed generation can be an answer to that. We can deploy our systems very quickly. We have fewer land conflicts than projects that may go through the siting board, for example. And our projects could be constructed, within 2 to 3 years of an interconnection application to generation. So very quick time frame for really widespread deployment. And these can be, near load or really anywhere in the state. That being said, I think it's imperative to fix these rules because we have major PJM issues, really concerned about keeping the lights on here. PJM has a huge role in that, but we have agency to control that. And I think it's imperative to fix the rules so that we can allow level 3 front-of-the-meter interconnections in a timely manner to deploy this new generation. Currently, we have developed a pathway that doesn't require enabling legislation. So independent of any bills in the current session or future sessions, we are looking to develop projects now. We have a market. So this is something that needs to be fixed now and is not tied to any proposal from the legislature. This is a significant investment that is ready for the state. My company alone is planning to enable to build dozens of DG solar projects over the next 5 years. This is hundreds of millions of dollars of investment in the state, thousands of jobs, tens of millions of dollars in local tax revenue. So there are big stakes here for us and for the state as well. As far as solutions, echo Mr. Kent's remarks, really the time-bound solutions for level 3 interconnections, as well as some technical guidance, are really critical. We need a cap on how long studies take, that there is not a reason that a system impact study should take more than 3 months. It's not a challenging technical document. I think if we had a cap on that, it would support these intercompany, planning and controls and transmission groups. If we have a backfeed issue that they need to opine on, if we had time, they would actually get that done. Again, it's really not that much work, and we see this in some states where we're getting 2-month system impact studies. Similarly, on a facility study, that is a lot more work. I think it should require, for those utilities that want to do the facility study, or if there's a technical requirement that we can come up with on a trigger similar to the level 2 rules, a time cap on that as well. That is a more detailed study and would encourage a requirement for a field visit as well. We have seen some facility studies come back that have taken a long time, that aren't accurate, that have also missed things in the existing level 3 rules for a system impact study, that have had serious impact for projects of mine. The other is, would love to see a bit better dispute review and resolution process. Outside of a formal complaint, we have worked with staff, again, to help initiate some of these studies and have had some very productive discussions and collaborations with multiple EDUs. But outside of a more formal complaint, it feels like we have no recourse for any issues to date. I did provide in there, some more specific recommendations on specific sections of the rule. I think, in summary, time-bound milestones, some technical requirements that would help make consistent mitigations across the state would be encouraged. And we will be submitting formal written comments as well. Thank you for your time.
Thank you, Mr. Davis. And for those requesting a copy of the informal comments that you presented, Mr. Davis, would you be willing to provide those to others that may request it?
Yeah, I have some more copies here and would be happy to email staff as well.
Perfect, thank you. Any others that would like to provide comments? Please.
Your Honor, just one suggestion, if there are no more formal speakers, since we have a lot of subject matter experts in the room along with staff, and some additional time, to the extent that there could be some dialogue between the groups and with staff on any of the issues. And I would appreciate if staff has any particular questions, maybe tee that up. Just thinking about how to use this time if it appears that there are no more formal speakers.
Certainly. If individuals have any specific questions, certainly we could try to attempt to answer those as best as we can at this point. Again, we don't have, when the commission is ready to solicit feedback on draft rules, we will do that. Unfortunately, we're not there at that point yet, but we can certainly listen to any additional concerns, particular questions, or technical issues that may arise. So certainly staff will be open to that. And if there are no additional individuals that would like to provide comments at today's workshop, we will go ahead and close, at least for the webcast purposes. I will advise everyone, as noted by Mr. Davis, I believe we have a hearing occurring in the hearing room next to us. We will be taking down that divider to provide them a little bit more room this morning. So just be mindful of that as well. I'd like to thank you again for all being here, providing your comments, your feedback, participating in this workshop. It is a very important step to kick off this process. The commission will certainly appreciate all the comments that we received today. And again, we will be providing those comments through entry to provide an opportunity for written comment at a later date. So please keep apprised of any developments in the docket. Certainly, we will let everyone know when that time comes and appreciate any written comments that we will receive at that point. So thank you again, and we'll go ahead and close it out.